Good afternoon. This is the Harbor Management Commission Plan Update Committee meeting. It's the 21st of October, 2025. In the first floor conference room with me is committee members Chris Smith and Don Hyman and our consultant Jeff Stedman. Let's call the meeting to order, and I guess we should pledge allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, do we need this?
I can see it very well, though.
Okay, we have the recording. So we have from Jeff a new Chapter 8.
A portion of Chapter 8.
A portion of Chapter 8. And so I guess, Jeff, the $64 million question is, why do we need this?
Well, I think we look at page 4. The stuff that I did was just sort of confirming or clarifying what the review process is. And this was an issue that came up when we were reviewing the POCD. And there were some people who said the commission didn't have authority to do it, which is completely contrary to the town code and the state statute. So I tried to summarize the review process on figure 1 on page 6. And it follows the same outline of what's in the plan now. But the significant reason I put this together now is on page 4. The middle paragraph with the underline. This deals with the issue that we're trying to grapple with now with the state legislature, and this is the policy or the procedure that the other towns updating harbor management plans are, and this is what we're pursuing now with D, the amendment of the statute to make clear. Well, first of all, that there is the authority of the Harbor Commission to review proposals to and by state agencies. And then the underlined paragraph with the underlining is two things stated there. One is that it's a recommendation of the commission that DEEP must listen to, in addition to any recommendations spelled out ahead of time in the harbor management plan, and to make clear that this does not supersede any of DEEP's authority. And that's in response to the commissioner's argument that we were trying to attain veto power over DEEP. So that one paragraph there, as part of the overall section of reviewing applications to state agencies, that's what we were discussing. And Chris, we had a committee meeting. Kim participated in it with people from New London and Stamford and Greenwich a week or so ago to discuss our getting ready to meet with DEEP to discuss just this prior to the legislature.
Oh, wait, no, I wasn't aware of this meeting.
Yeah, it was just a...
Remember, Kim was authorized to represent the Harbor Commission as a guy from Greenwich, Stamford, Norwalk, New London, and a fellow from Norwich wanted to participate. So that was the discussion a couple of weeks ago. Now we thought we were reaching out to DEEP because DEEP had agreed to meet with us. And then today we learned that DEEP had already contacted the Environment Committee of the legislature, which reached out to the fellow in Norwalk, talking about having a meeting to discuss just this. But we're going to have to, that's contrary to the process that we had talked about with DEEP, that we meet with them before talking with any legislators. But the main point is that to make and this is what we're doing in New London, which has a plan ready to submit to DEEP for approval, is to include just this statement. Recommendation of the commission is binding unless DEEP shows cause otherwise. And that's what DEEP approved in the Greenwich plan, and that's what we're hoping it would be.
So this paragraph is the same paragraph that's in the Greenwich plan. Yes. And when was that approved by DEEP?
2017.
Okay. And then this paragraph is also ready to go for New London?
Yes.
Okay.
But clarification question. Is it the case that our present plan, which was 1995, I think, doesn't have language resembling this in any way?
Yes, it does.
It does.
What this is doing is it's a little bit fine tuning based on what's happened since, but it's the same outline. Commission has authority and is responsible for reviewing applications for local approvals, land use approvals, and the commission has in the harbor management plan for reviewing applications for state approvals.
So it's a refinement of that language, enabling us to do what we're doing, consistent with what you understand other harbor management or commissions are doing.
Mm-hmm.
And then ultimately, this will be reviewed by a number of bodies, but as it goes through the process, it has to be reviewed by our people, by DEP and by others, right, before it's
RTM and DEEP.
RTM is the adoption. So the first step is the understanding or agreement by the Harbor Commission, and then the submittal to DEEP for review. DEEP will likely have comments, and that's when we're going to get into this discussion. And then it also requires approval from the Connecticut Port Authority, which is interesting, because previously, back in '95, it was the Department of Transportation, because the DOT had its maritime division. Now those responsibilities were transferred to the Port Authority, which will have a responsibility for commenting and approving. And we've been talking with the Port Authority about this and what we've been doing with the plan, and they understand that one of the reasons that we're still working on the plan is twofold. One, we wanted to get agreement on what the dredging project would entail, and what DEEP approved for the federal dredging, which was to restore the 100-foot width of the channel. So now that's something that we can put in the plan. We don't have to argue with DEEP about that anymore. But it's also understood that the uncertainties with the judicial decision affect all of the plans, including the ones the Port Authority has to approve them all. Because not only does the court decision not recognize the recommendations of the Harbor Commission, it doesn't recognize the responsibility of the commissions to even review state applications.
It doesn't recognize they don't state that they don't recognize it, or they just don't act that way.
The judge ruled that there is no legal authority for a Harbor Commission to review applications for state approvals.
Jeff, do we have that which was in the original document that covered this compared to what it is that we're looking at right now?
I didn't send that. I should have sent that.
Having to see those, so I mean, I didn't see chapter 8 in the prior document that I saw.
No, we revised the outline of it too,
right.
Because the current, what's it called, chapter 6 has recommendations for specific projects as well as recommendations for implementation. So we broke that up into two chapters. We have it.
So as a result, really, to compare the old with the new, and I'm talking about the entire new with the redrafted outline, would be a very difficult thing to do. No, but what I'm getting at is, as I've been thinking about this, is, are we doing a revision, a rewriting of this document, or is it an update? And it's starting to feel more like a revision or rewriting, in which case, we have to have, if I were the RTM, I would dig much deeper than a regular update, which just says, we changed the date, we put a period instead of a comma.
But yes, if we look at, and I should do that for the last chapter, because we did that for
I think for the whole thing.
Yes, for the goals and objectives and the policies, we showed the changes. So the additions are in bold and the deletions are struck out. But we should do this. It's just a little bit difficult because we're splitting up that last chapter into two.
Where in the old document is this?
Just bear with me.
Because it looks like to me it's just the first clause that is different. But
we're talking about this whole document, or just the paragraph on.
I'm just talking about this right now.
I just pulled out this one paragraph to discuss today because it's pertinent and current with what we're discussing with DEEP. but it's on page 6-34 at the bottom,
In the existing
in the existing plan.
6-.
And I also added that figure or summary table.
And I have a question, Kim, after you're done with that analysis.
So it's the same outline as what we have, but,
I'm sorry, so beginning on 6.34, at the top of the page is the text that would be replaced by this text.
number 3 on page 6-34 is one of the responsibilities of the Harbor Management Commission is to establish and carry out this application review procedure.
And that would be replaced by the paragraph 4, on page 4 that you sent,
It would be replaced by the
the entire document.
the entire document. I mean, some of it is just little editings, but significant part is in the section on the state.
Can I ask a question? That's very relevant to this. Has the language that you've presented to us in this document, and that I gather others are looking at elsewhere among your other clientele, has it been reviewed by an attorney, or does it need to be reviewed by attorneys? Being that so much of this language is legal language, you're an attorney, I welcome your opinion.
No, I would say no.
I'd say no, too.
I would say no. I mean,
Let DEEP object to it if they do.
I mean,
But this is what we feel is the right thing to do. I don't think we need to have somebody,
I mean, anybody,
They agree.
yeah,
Okay?
I mean, it's consistent with the statute.
I asked because we're dealing about law and procedure here. Wondered if the lawyer had to review it.
No, I don't think so. I don't think so.
Thank you.
I guess the other question that I have, Jeff, is the bigger one is, where are we?
Yes, there's a lot still to do because I haven't broken up in the chapter 7 where we had, just for example, if you look, well, the outline of chapter 7 and
The new chapter
the new
7.
chapter 7. But I haven't prepared that yet. We have the outline of it and the locations.
I'm lost. We're talking about this chapter 8?
Well, I just wanted to know kind of where we are in terms of this whole document.
The overall,
Yeah.
the overall update process.
Yeah, I thought we would be looking, today I thought was the day we'd be sitting down and look at your work on the entire document that brings in all the comments and discussions that we've had into a draft that we would then.
I don't have that.
I see.
There's much more to do. So the main part now is to take the old chapter 6 and break it up as we outline the new chapter with area specific recommendations, and then have the implementation section separate, the last section. So implementation, I can probably do that for the next
Implementation.
Which is the new 8.
what I sent today is part of plan implementation.
Yeah, and again, a lot of what would be important to me would be to see what we had directly compared to what was being proposed. And are we deviating significantly such that it becomes a revision instead of an update?
Well, we have,
I don't think so, because the responsibilities for implementation include actions of the Harbor Management Commission, include responsibilities of the harbor master, and I mean, there's other, you know, state and federal entities that have a role in implementation as well, and also the land use, agencies, because they're required to refer applications to the commission.
So we will have two new chapters. Chapter 7, or two new materials. Chapter 7, which is area-specific recommendations. So that's where we talked about the channel and the jetty and the wall and the Perry Green and the yacht yard and the outer harbor and the inner harbor. That's the new Chapter 7. Specific recommendations that we wanted to include in the plan because of the Cohen decision, which says if you don't have mention of these projects or these possible projects in the plan, DEEP doesn't have to pay any attention to your recommendation.
Right.
So Chapter 7 was to Cohen-proof, if you will,
Right.
the plan. Chapter 8 has become a new chapter as well with the implementation outline.
Yeah, and also previously, we had the goals and the policies in one chapter.
Correct.
So we broke those into two.
And we broke those into two.
And those are both shown with respect to changes to the existing.
But the two new chapters are really the area-specific recommendations and the one on implementation.
And those are what I'm trying to work on now.
We updated, there's one chapter, I think it's Chapter 2 or Chapter 3, which is just a description of the harbor. That was a significant amount of time just to get,
You know, also, I asked Travis at the Yacht Club to look at the section on the Yacht Club to make sure that that's current with what the facilities the Yacht Club has and what it does. He said he would do that.
So at the end of the day, will it be possible to produce a red line version of the plan? Or some way for us to know everything in one place that's been changed?
With respect to everything except, the difficult one is the area-specific guidelines and the implementation.
Because those are new. I mean, not,
So,
well,
be organized, but I will do my best to have the implementation section. I'll go back and redline the whole thing, that,
I guess I wondered why, except for that one paragraph, the chart, the figure 1, couldn't have been the whole.
well, that's another possibility.
And then, why even put that in the plan and just act that way? This is just this is the procedure that we follow.
So, because I think it's important that DEEP approves it. DEEP has to approve the plan, and we need them to accept that, first of all, the Harbor Commission has authority to review the state applications, and second, that DEEP has to listen to what the commission says.
Right, but that,
Absent DEEP approval.
That's stated in state statute and state, and town statute, right?
No.
You said it was. I mean, that's what that document says.
Well, the referral and review of applications to town agencies, that planning and zoning refers it. But what's unclear now, or what doesn't exist according to the court decision, is the authority to review state applications, and also that DEEP has to listen to the Harbor Commission's recommendations.
But I thought it was stipulated in that finding that if it's not, anything that's not listed in the harbor management plan will not necessarily need to be listened to by DEEP.
Yes, that's what the court
So
decision.
if you put in the section, Chapter 7, which is the areas of concern, the Chapter 8 is the implementation. This is just what we do. But the chapter and verse in terms of regulations from the state and local are just simply, that's what we will, the procedures that we will follow. Why do we need to put that in the document? And the reason why I say that is it a red cape flying in front of the bull called DEEP in the case of getting approval to throw something like that into the document, that they say, well, the whole document itself we would have agreed to until I saw this last Chapter 8.
And they may very well say that.
Then if that's the case, why is it essential that it's there? Let's put it that way.
I think it defeats the whole purpose of the harbor management program if DEEP doesn't have to listen to the commission's recommendations.
But they do by the regulations that are stated, that are already there on the books, right?
No. They've made the argument that they don't have to listen to a recommendation of the Harbor Commission. They only have to listen to a recommendation that's specified ahead of time in the harbor management plan.
So then we make those areas of concentration known in the plan, and then we can then follow that rule.
My sense is, respectfully, that undermines all the other harbor commissions.
Well, but
DEEP has approved, that in the Greenwich plan, that they have to listen to a recommendation of the commission. That's what we're pursuing in the state legislation.
Right, but so that was in 2017, and we don't have any evidence since 2017 of what DEEP would do, except for the Cohen decision, right? Because there have been no other harbor management plans.
But we have instances in other towns where there's been public hearings, and the hearing officer has made the statement that the Harbor Commission has no more authority on this matter than the general public.
Than the general public, right.
And that was done twice in Norwalk, and it's ongoing now in Greenwich, and it will happen probably in a hearing, another hearing ongoing in Norwalk.
Because those are over issues that were not previously stated in the harbor management plan, and therefore disregarded by DEEP?
But the argument is that no plan can identify an answer to every issue that's going to arise.
Sure.
It has to involve some sort of a assessment by the Harbor Commission. And again, though, it does not overrule DEEP. It just means that the agreement that DEEP made was simply that they have to listen to the recommendation, and if they do something different, they have to explain why.
We know that, and we know they know that, but we know that they're not going to want to listen to that, because that, in their mind, erodes their authority, and we want to make sure that that's our authority.
And that's the purpose of this committee that we're now working with the other towns to work with DEEP to try to reach an agreement.
I understand. What I'm saying is, and I don't disagree with any of that, Jeff, and I perhaps I'm not really explaining myself well. I'm just looking for the plan that we put forward to be approved and move forward with it. And if we throw a lot of things into the document that sends up red flags to those who have to review it, such as DEEP and RTM in town of Fairfield, will that hurt our chances to get the document approved? And if so, are there workarounds on that to make the document equally strong, yet not controversial in the way that might cause it not to be approved?
Well, I would argue we'd be better off not just staying with the old plan. If we were not going to address this issue of the authority.
Well,
the old plan has gotten us, we're functioning fine with it. We were going to update it, and also, include the understanding that we can maintain the 100-foot width channel through that sandbar.
Well,
otherwise, if we don't address this, I think it's.
But I would suggest that we move ahead with what we're doing. We focus on chapters 1 through 7. We get chapters 1 through 7 ready to go. In the meantime, this committee is looking for an opportunity to consult with DEEP. New London will present its plan to DEEP with the language, similar kinds of language in it. We will see what happens. And if we've got chapters 1 through 7 ready to go, and we will learn something from the New London experience and from this committee's meeting with DEEP, we can then decide where and how to present chapter 8. But we're right there ready to go with all of the other 7 chapters, which I think we've done a great job on. I think we've been thorough and updated not only not the descriptions, but the possibility of projects in other areas. We've got the dredging done. We've got online mooring that we need to add in. We've got we've got the work at the lower wharf that's going to be done. I mean, that's all those things are big changes since 1995, and we can if we've got chapters 1 through 7 ready to go, and we learn something about implementation from the London experience and from the committee meeting with DEEP, we've got a draft, and we can modify it. That shouldn't take too long to decide what we're going to do about chapter 8.
Yeah, I think in chapters 1 through 7, as you clearly point out, the changes that we've made and are talking about are updates. Things
Correct.
have changed since then. This is what we are today.
Correct,
And we're addressing those issues.
correct.
Chapter 8 is something different entirely. And do we risk,
It's different entirely with respect to one paragraph.
sorry?
But
My
you say
question
that
is,
will
do we risk
Red flag.
losing 1 through 7 because of 8? And if so, if that's the case, what can we do to make that work better? Maybe, for example, maybe the precepts of chapter 8 is mentioned in the foreword or as a whereas in the very beginning, in that this is just, this is how it works and how we will work, rather than, there's something about this when you read it that it sounds like we are telling DEEP and everyone else what they have to do, conservation, shellfish, and blah, blah, blah. You've got to do this, you've got to do this, we want to do it. And Jeff, I get it. We may need to have that right, and we don't want our rights to erode. But we're asking for those rights here. We're asking for those rights to be written into this document. And when we throw it in their face in that way, we may get it thrown back.
Well, my comment on that was all the stuff at the implementation section involving shellfish and pre-application, that's all in every plan. The only thing that we're pushing now to clarify is the authority to review state applications, and the DEEP must listen to what the commission recommends.
Those prior authorizations with shellfish and conservation, those are in this plan, the 1994 plan?
It talks about, but they're in all the harbor management plans.
I'm talking about ours, though.
We have it mixed together with respect to.
So if it's not there, then it's coming in as an addition. As an addition, does that put up all chapters 1 through 7?
I'd say that would have nothing to do with DEEP's, because all we would be putting in the implementation section is what's been approved in every other harbor management plan. The only thing that's different is the section, clarifying that they have to listen to the commission's recommendations. And that's what we spent all the time, and all the commissions, that have been involved with the legislative process, the public hearing last year. It's essentially one paragraph.
We should look at the language of those harbor management plans that have adopted this sort of language, and what sort of language they have got through DEEP.
That's what I work with.
But
Because
they
that's what
had,
you've done,
That's
right?
what I work with: Stanford, Norwalk, Stratford, Norwich, drafting New London.
but they haven't been approved since the last one was 2017.
Well, that
And
again, we're only talking about this issue of the recommendations of the Harbor Management Commission.
Right, but that decision was like 2020, 2021,
Yes.
the Cohen decisions. So we don't know, my point is that we don't know what DEEP has approved that language in lots of places, but we don't know since Cohen if they're going to change their approval. That's my concern.
I think that we have, enough job to get everything together, and that the only thing that I think would be objectionable, to DEEP and would lead to discussions and conflict is the section on the recommendations of the Harbor Management Commission, and it's one paragraph.
Right.
I think that the job is to get the whole document, squared away. We've redone a number of the maps. We have to illustrate it with more current photographs. But I think everything else is just a question of putting it all together. And
There is one designation that I know you're going to think about changing.
no, we can do that, Don.
That's
That's
the
the last
easiest
thing that we have.
issue in the world.
What's that?
He knows what I'm talking about.
Oh, Lower Wharf.
Town boatyard to
Town
yard.
But in that paragraph, the paragraph, the portion that's underlined, that's commentary, right? Or is that actual?
Well, I just underlined it to emphasize it. But we've talked about in pursuing the legislation in response to Deep's unreasonable argument that we were trying to obtain veto power over Deep. And that one of the suggestions, and it came from the Greenwich Town attorney, was to make clear that by doing this, this doesn't diminish any Deep authority.
Yeah, I get it.
That's the only reason for putting that in there.
I get it, yeah.
But what I'll do is go back and take the implementation stuff and just organize it.
Or if you could just cite to where it is in the 1995 plan.
But I should do this. We should do the same thing as we did, if I can do it, because there's a mix in that last chapter now between projects, including the project to realign the Federal Navigation Project, which is something that was done. So that's essentially eliminated.
But let me ask another question, and it's going to come up at our 4:30. It relates to the POCD, but it ties in at the top of page 3 of this document. If, for example, with the case of, now we're not talking about D, we're talking about local approvals. If we make recommendations, as we did to TPZ regarding a document, as we did regarding POCD, does the fact that we're making recommendations also mean that we don't approve? Is
Favorable or not favorable?
Yeah, is it synonymous? Is making a recommendation synonymous with not approval? That's right, I don't know.
Or
No.
if I mean, it could be. I think that's a secondary decision to be made. One is you make a recommendation, because you think that the document would improve with that recommendation.
Right.
And then the second point is they choose not to accept that, presumably with some sort of reasonable explanation why. And then you, as a commission, say, well, because of that, we cannot give a favorable recommendation for this, or not. Or maybe we say, well, even though you don't include our recommendation, we still give you a favorable.
That sounds totally sensible. Does it need to be, does that procedure, or that way of thinking, need to be articulated so that future commissioners know they have that latitude? I don't know. I'm just raising it because we're in this situation, or maybe, if we want to be, with the POCD. And would it be helpful to our successors to know that, to guide them that they have a choice? They can make a recommendation and still approve, or they can make a recommendation and not approve.
My feeling is that that's very simple. And if the statute makes it clear, and so does the town code, if the commission does not make a favorable recommendation, then it requires a 2/3 vote. So the finding of the commission could be, we have no objection. And then I'm thinking how it's done in other towns. We have no objection, or we find it consistent with the harbor management plan, or we are not able to make a favorable recommendation for these reasons. It's just crafted in the form of the recommendation that's made.
Okay.
And that we do that.
I think our own situation with the POCD is, some would say there's a little ambiguity in where we stand.
Yes, and it wasn't, when we wrote the letter, we made comments, but we didn't say that absent, addressing this, and now.
But I mean, don't they know, I mean, we're talking about people who know their rights and obligations, and we would expect the TPZ to know that if they got an unfavorable commentary from HMC, that would trigger the 2/3 vote. And conversely, if they got a favorable from us, that wouldn't. But if they got an unfavorable from another commission, like Shellfish, it would trigger it.
No, Shellfish doesn't have the same.
You know what, I'm just pulling a name out of the hat. Just another commission.
Yeah. The other commissions, the 2/3 vote applies to the Harbor Commission. So we get.
Only harbor.
Only
Yes,
harbor.
only the Harbor Management Commission, and that's pursuant to the Harbor Management Statute.
Okay, so then they know that's that authority power
Well,
that
they
the harbor management has.
they should know, but in other instances, in other towns, that, they.
But if they don't know and they act without knowledge of that, and they go on and we give it unfavorable, and then they vote and it passes with a simple majority, we can raise our hand and say, that's not correct, you should have had a super majority.
Yes.
Or we can just say nothing.
Or nothing, we just do nothing. But I mean, I guess really where I'm going is it's mentioned in this document 3 or 4 times, 2 or 3 times anyway. And we mentioned it numerous times in our recommendations to POCD. And I'm looking for diplomatic opportunities, not ways of getting ourselves deeper into a ditch where we have further problems, where if we're saying to the TPZ or DEEP or anyone else, you better watch out, because if you don't get us to give you a favorable, you're gonna have to vote 2/3. If we just not mention that at all, because it's a statute on the books, we don't have to mention it, that quiet power might be more effective than rubbing noses in it.
Well, and that's why this is so effective, I think.
But
Because it's got the statutes, it's got it's a little bit of commentary and end of story.
But I almost think that would be something, if you have an onboarding for committee members, let's read this document. Let's
Right.
make sure you have this one understood
Right.
as a
Right.
commissioner.
Right.
2/3 vote and this process that is in this most recent paper that I did, that's all in the existing plan. And my feeling is that, it's going to come up in Stanford tonight, actually, with respect to the Stanford Master Plan, POCD. And the Harbor Commission's concerned that they may not have addressed the Harbor Commission's comments. But the question is, what do you do about it after the fact?
Yeah.
There is no real remedy, but the understanding is that Harbor Commission does its job and not taking directions from anybody else, and if planning and zoning chooses to do something else, well, that's the way it is. But
I mean, for a realistic example, I mean, we there is a project that TPZ is being asked to opine upon and pass.
Mhm.
And we are given the opportunity to comment. We make our comments and we say, these things are putting the best use of Southport Harbor at risk, and they need to be remediated in the project that they're planning to employ. And the TPZ says, no, we don't care about that. We don't think that's relevant, and we're going to find in their favor anyway.
often happens.
What's missing there is that them coming to us and saying, your recommendations of those 3 remediation points do not have merit for the following reasons. As a response to our recommendation, here's why we're not accepting your recommendation, and therefore we find this way. And then, I mean, you can have a back and forth, I would imagine, at that point, but for all intents and purposes, off they go. And at that point, if they've responded negatively to our recommendation, can we then give an unfavorable finding?
Because then it's after the fact, though. The recommendation has to be provided prior to or during the public hearing to act on it
So you're saying that your recommendation has to have that tag saying, if you don't accept this, we will give you an unfavorable.
Well, that could be part of the recommendation.
Is that what you're saying?
That we have no objection to this project, provided, and then list the conditions, and then also just list the statute.
So that implies that if we don't object, if these things are included in your finding, it implies that if they're not, you'll get an unfavorable, and you'll have to supermajority vote.
But by then, the Harbor Commission is, unless there's an appeal of some sort, the Harbor Commission is finished with it, because they act, to approve or disapprove. And if for some reason they violate the statute, or they don't accept the statute, then that leaves open the question of what's the remedy for it.
Maybe I'm splitting hairs and I'm not being very clear, but just in terms of process. So we go and say, we will object to this project unless these things are listed or
You could say that.
We're saying that, let's say, okay? They then go through their machinations and say, we disagree with those recommendations for the following reasons, and now approve of it. But that approval, because they know that we've given our recommendations that, we would conditionally, they know now that when they do that vote, it must be a supermajority.
They should, yes.
And if they don't, we're fully upset about, we're very upset about this, we're going to raise our hand and object to procedurally what they've just done.
Yes.
In which case they could have a supermajority vote and still win.
But what we're talking about is in the plan now. This isn't something that we're adding in any way, the 2/3 vote or the time period to provide it.
Yes,
That's all in chapter 6 right now.
And again, my
Beginning on 6-35.
very, very important kind of procedural nuances that you can discuss. Do they need to be written anywhere to guide future people? Or should it just be something people intuit?
Yeah, I mean, is it something that we use as an onboarding for commissioners, that this is how, you have your FOIA, freedom of information training, here's your, Robert's Rules training, here, it's a half day of this, and, Jeff comes in and explains that to us.
I think that's a great idea.
Yeah.
6-30.
34?
35, is that what I said? 6-35. It might be interesting, Stanford, of course, is a much different situation where every month there are 3 or 4, or sometimes 5 applications to review. And what the commission has done, what we've done in Stanford, is we have a flow chart of the process, both for state reviews and local land use reviews. We actually got into quite an argument in Stanford at one point, or an argument with the land use bureaus that the bureau was essentially playing zoning department, took the approach that in order for it to be reviewed to the Harbor Commission, it has to be a project that's on the waterfront. And we argued this and pointed out that that's not what the statute says. It says projects that could affect the harbor. And clearly projects don't have to be on the waterfront to affect the harbor. And then land use agreed with that, and that's part of the process.
So we have, in 635 to 37 is now chapter 8.
Part of it.
Most of it.
I pulled it out, and I did some editing, but it's essentially what's already there. But it's all part of the application review process. But the arguments that TPZ seemed to be making was that a plan isn't subject to this review is just not valid.
Yeah, no. I mean, so I can see where this language is present. If you kept the same language, what would you add to make your chapter 8 the same?
I did a little bit of edits based on what's in other plans, but it's essentially with respect, it follows the outline that's in chapter 6 in the section on the harbor management consistency review process. I just pulled that out because I thought it was important to discuss it, given our recent interaction on the POCD and the ongoing work with DEEP and the legislature.
So chapter 8 and 6.35,
35.
is that we're repeating it or repeat it?
Well, this is going to come out.
It replaces.
It'll be in the other responsibilities of the Harbor Commission to initiate actions needed for dredging. That will still be included.
Right, but this
ongoing examination of the plan.
Let's talk about chapter 8.
Yeah.
I mean, this chapter 8 will remove all other mentions in chapter 6 of the same language.
Oh, yes, it'll be taking relevant stuff that's for implementation from chapter 6 and just putting it into into a
Okay.
new chapter.
Then why don't we put it back, I'm thinking in terms of making it just an update and not a revision. Why not just throw this into chapters, improve the language in chapter 6 with this?
Well, we could do that.
And I think this is a perfect document that explains exactly the process that we would follow. Is that something that belongs in the plan or in our manual of operation in the commission?
We've done similar.
We should.
We should.
We could, but,
A charter.
I mean, I like figure 1 too, of course.
We thought it would be a more logical document to not mix particular projects with implementation and to put them in separate chapters. So chapter 7 would be, our what we say about specific areas. The yacht yard, the town, Lower Wharf, the navigation channel. Those are area-specific recommendations, and it would also fit in with potential projects that we would want to pursue, including, grant projects. But that's not that's not the responsibilities for implementation, and that's why.
Well, certainly, this is such a big document, sometimes it's hard to find things. So if there were to be a chapter on implementation, you would know where to go to look to find the implementation stuff instead of being in chapter 6, which is recommendations and water use plan.
So, okay, I'm trying to pretend to the time, because we have to go upstairs to start the next meeting.
Yeah.
But if then in a cover letter to, let's say, DEEP and RTM, who are the approving authorities for this, you would say, you will note that the structure has significantly changed to make it easier to find.
Organization is
for organization, and simply say that, but the language has simply been moved from one section to the other.
With some edits, yes.
And this
The
is,
edits are shown in red.
and this is our new chapter 7. Chapter 5 and 6 used to be chapter 5.
Yeah.
So,
But also, in the other plans that have been prepared since this, there's also, in terms of implementation, the legislative body has a role. So does the, in other towns, the mayor. Other town agencies have a role in implementation. So do state and federal agencies as well as private interests, and so does the general public. Those are all standard implementation items that are in all the other harbor
But
management.
not this one.
So we could simply add those from the other plans.
All I'm thinking is how we can get from a document that's been updated and some revisions to approval from agencies, particularly with DEEP, who have been pushing back in very meaningful ways, such that we may not feel as confident in getting approval. So I'm not wanting to sugarcoat it. I'm just wanting to put our best foot forward to get to where we want to go.
I understand, but my feeling is that the other towns are all in together, is they have to stand up to what DEEP reneged on what they approved in the Greenwich plan. And the argument now is, and the town attorneys in Greenwich recognizes it, the principal argument against making the legislative change has come from the DEEP attorney who argued the case,
Right.
both in the court and in the hearing, arguing that they did not have to listen to the Harbor Commission's recommendations, even though they had approved in the plan that they did. And that's the issue that we're grappling with, and we thought if we could get a fair discussion with DEEP and to make clear that we're not trying to take away any DEEP authority.
But I mean, they'll get our recommendations, okay? And if they don't give us reasons why they don't accept those recommendations, we have little recourse except to raise our hand and say, you know, you guys are acting unfairly.
The recourse now is the legislative change.
Right, but
But that would mean that we would take them to court. We're not likely to do
we're not
that.
gonna do that.
Oh, no, we wouldn't take them to court, but we're working on the legislative change now. The next session starts in February next year.
So, but if we go ahead and we finish up chapters 1 through 7, by the time we get to 8, we may have more information based on meetings with Deep and the New London experience, so that we could then very quickly modify this to get it through.
Right. And that last part of it would be relatively simple. The last modification.
We would be responding to whatever it is they've said, or whatever it is new legislation says, or
Right.
whatever they've done
Makes
with
sense
the
to me.
Norwich plan. And I think that we have to get together once more, at least once more, to take a look at the whole
Yeah,
thing, redlined, not,
And
Yeah.
and
I
also,
mean, we're not-
respecting what Chris said, chapter 8 may become part of, again, the old chapter 6, just cleaned up according to. I think you said that.
I did, unless we strongly feel that the flow, we can argue
Yeah.
that we've reorganized the
Right.
flow and structure of the document, and that the adding of a chapter 8 makes much more sense because it's more usable. If that's the case
Yeah.
that we make, then,
Yeah.
but if not, and if by adding a chapter 8, we cause people to like, wait a minute, how much of changes have you made here? I'm not sure that I want to agree to this anymore. Let me look at it very, very closely, and next thing you know, you're sort of,
You're on the defensive.
and
yeah, totally
trying to
agree,
avoid that.
totally agree, totally agree.
You don't
Okay,
mind?
no, we've got to run. Meeting is adjourned.
Thank you.